Good afternoon and welcome to another edition of the Daily Fix. I am your usual host and presenter, Advocate Thulo Hoyane. It was another day in the Pretoria Magistrate's Court where we just saw things go south. This was during the appearance of Dumisani Khumalo, the crime intelligence boss, and his co-accused, who were seeking to bring an application before the Pretoria Magistrates Court to have their bail conditions relaxed. You'll recall that Dumisani Khumalo is out on bail and is facing charges of corruption involving the irregular appointment of a person, an unqualified individual, some lady, very young lady, I think she's about 26 years old, to a very senior position without following due process. So that is the corruption case that Dumisani Khumalo faces. Now, in the interim, it would appear that the Commissioner of Police has made a decision, he has sent to an affidavit. I think Advocate MSHOLOLO was in possession of that affidavit, to say that they can go back to work. You know, while they are on bail, they can go back to Dumisani Khumalo specifically can go back to work while he is on bail. So it then was that Advocate MSHOLOLO then approached the Pretoria Magistrates Court to have those bail conditions relaxed, right, or amended to enable Dumisani Khumalo to go back to work. It all started off, you know, on a very theatrical note. There was Teffo, who was Malefela Teffo, who was present there. Malefela Teffo, you know, is always trying to hog the headlines whenever he gets the opportunity. So Teffo, out of the blue, just surfaced there and wanted to be a friend of the court for some reason. And then he stood up there in typical Teffo fashion and even started going into the merits of the matter to say that, you know, Khumalo is involved in this and that without having filed any substantial papers to be a friend of the court. It was at that point that Advocate MSHOLOLO strongly objected to the attempt by Teffo, you know, to make that application. MSHOLOLO argued that there is no application before the court, and the West still, Teffo is now making, you know, casting aspersions on headline Dumisani Khumalo and making very disparaging remarks or comments about Dumisani Khumalo. So Teffo was then, you know, sort of brushed aside, and the court then, you know, focused on the business of the day. So the business of the day revolved around this review of these bail conditions that Dumisani Khumalo is seeking to have relaxed. And what a misdirection, you know, transpired there. MSHOLOLO rightly, you know, argued that, or let me start with the prosecution. The prosecution was arguing that they intend, and that word is very important, intend. They have an intention to file an application in the High Court to review the decision of the previous magistrate who was handling this matter to recuse himself. The magistrate who was handling this matter has recused himself. And that recusal of the magistrate is very important because I'll be taking it up first thing tomorrow morning on the Daily Fix, because it is directly linked to some of the disclosures about, you know, the involvement of judicial officers or the judiciary, you know, in corruption. Anyway, what the prosecution was then saying is they intend to bring an application before the High Court to have that decision reviewed. And they were opposing the present application that MSHOLOLO is bringing up before the Pretoria Magistrate Court on the basis that they only intend. They had no application filed before the High Court to have that, decision by the magistrate reviewed, that recusal decision by the magistrate reviewed. They had no papers in front of them. I mean, there were no papers filed with the High Court. All they had were copies which were going to be served on the High Court. But it was very disappointing to see all this unfold, because MSHOLOLO then objected and said, this application to have the bail conditions reviewed cannot be held in abeyance pending the finalization of an application yet to be filed, which has not even been filed, an application yet to be filed with the High Court for the review of that decision of the magistrate to recuse himself. And that, not to hear this application will be prejudicial to the accused persons. It will be prejudicial to the accused persons because they will not be able to access, or they will not be able to go to work. So the magistrate then had to, make a decision along those lines, whether to grant MSHOLOLO, the opportunity to go ahead and move or proceed with this review application, this bail conditions applications review, or whether he allows the prosecution to go ahead and file those review papers in the High Court, and he then holds these proceedings to have the bail conditions of Khumalo and co-accused, held in abeyance pending the finalization of that application, which the MSHOLOLO was saying is prejudicial. And Advocate MSHOLOLO was rightly arguing that this application to have the bail conditions of the accused persons, relaxed or amended, right, can proceed, right? Can proceed, and pending the finalization of that application to have that decision reviewed, which I think was a very plausible position to take, because it would then mean that the bail application, the bail conditions amendment application would then proceed, but it would not be held back by the fact that there's an intended review. An intended review application, that is my problem. An intended review application before the High Court, which has not even filed before that, which has not yet been filed before the High Court, and whose outcome nobody can, can tell. No, nobody knows what the outcome of that application will be, right? It might well be denied. But the magistrate totally misdirected himself and said that this application to have the bail conditions of Khumalo and co-accused, right, reviewed, cannot go ahead. It will have to be held in abeyance until the finalization of this intended, review application in the High Court, without a date. There is not even a date on which that review application is going to be proceeded with in the High Court. Because the papers that they had and were showing to the court and to Advocate MSHOLOLO were not yet filed in court and had no date. So the prejudice to Dumisani Khumalo and co-accused is huge. They now have to wait for that review application. Nobody knows when that review application is going to take place in the High Court. And it is not even guaranteed that, nobody knows what the outcome of that application will be. So I think this was a complete misdirection on the part of the magistrate, who ought to have proceeded with this bail conditions review application by MSHOLOLO, right? And then there would be that parallel process in the high court, who should then be, taken care of as and when the time comes, because it is not even before him, and it is not for him. That is the magistrate. It is not even for him to talk about an application which does not exist, because if an application has not been filed in court, it is non-existent. This is where the misdirection came up. But the position that the magistrate took then was to deny MSHOLOLO, the right to proceed with this bail conditions review application rather, on behalf of Dumisani Khumalo and co-accused. And the matter was then postponed to the 6th of November, if I get that date right, to the 6th of November. Possibly then in the meantime, the prosecution will go ahead and have that decision by the previous magistrate to recuse himself reviewed. But I think it was a gross injustice and a blatant misdirection on the part of the magistrate to have granted the prosecution that application. Having said that, let me thank you for watching this video. Let me thank you for all the views and subscriptions and likes that I'm seeing. I am so highly motivated these days to seeing the support coming from you. Have a wonderful, wonderful day.